Hello everyone, I'm continuing with mortgages. So about the right to redeem, the mortgagee mustn't postpone the right. Of course, he is allowed to earn interest on the loan, and that's the only way that these businesses can make a profit. So then he can postpone the date of redemption a bit, but postponing it so much would make the equity of redemption really a fallacy, and that won't be considered valid by the courts. So this is a matter of degree. It's not something absolute. In Fairclough and Swan Brewery Company Limited, 1912. The claimant, he held a 17-year lease in a hotel and borrowed using the lease as security. The contractual date for redemption was set to be weeks before the lease was supposed to expire. The right to redeem wouldn't arise until the contractual date had gone. So there were only a few weeks of the estate being free from debt, so the mortgage was in effect irredeemable and the postponement was void. But in Knightsbridge Estates Trust and Burn, 1939, the contractual date for redemption was set 40 years in the future. Despite that, the postponement term was enforceable because the parties were businesses and they had equal bargaining power. The mortgage estate was freehold. So there's this doctrine of clogs on the equity of redemption, and it's come under a lot of fire in the last few years. So Lord Phillips, as Master of the Rolls, head of the Civil Division, said it was no longer useful in the Jones and Morgan 2010. When it comes to commercial mortgages, it's unusual for the terms to be held to be invalid through equity. Usually, the terms of such a mortgage are held to be proper, and then they're enforced by the courts. There's statutory protection for mortgagors, and that's what I'm going to go into right now. So mortgages are things which come under a lot of statutory rules. So the particulars in these is too much for me. But until recently, there were two regulatory regimes, and the Financial Conduct Authority was responsible for them. Prior to the recent changes, first legal mortgages of residential properties to be occupied by the borrower were regulated by the Financial Conduct Authority, FCA, under the Financial Services and Markets Act 2000. The FCA handbook was Mortgages and Home Finance Conduct of Business, and that was published by under the Act in 2000. And this adumbrated the particulars for mortgage lenders, how to deal with the mortgages as per that 2000 Act. So anyway, mortgages which used to fall outside FCA regulation, such as second mortgages, mortgages for other purposes, buy-to-let basis, they were dealt with by the Consumer Credit Act 1974 and its 2006 iteration. The two regulatory regimes are mutually exclusive. Okay, it can be one or it can be other. It can't be both, can't be neither. The FCA regulated mortgage was outside the consumer credit legislation and the other way around. But the government decided the responsibility for regulating second mortgages was going to come under the FCA, and as of 2016 that happened on April Fool's Day. Don't let that fool you. The regulation of consumer credit legislation was passed to the FCA. So this completed the Treasury's goal, fulfilled their goal of having a single consistent regulatory framework for the mortgage market. It was too confusing to have two different ones. And they thought illogical. So consumer credit statutes were intended to protect borrowing for people with low credit ratings, otherwise they wouldn't be able to get loans. An example is Falco Finance and Goff, 1998. It was not reported, but Mr. Goff, he borrowed money, he got a mortgage, and the terms were there for a flat annual interest rate of almost 14%. It was discounted to 9%, but the mortgage term said the 5% discount would be lost forever if he ever went into arrears. And of course, he did go into arrears. The dual interest rate was found to be extortionate credit bargain under the CCA, 1974. Because they said it's impossible for any borrower to make all the payments on time. That's not true, actually. Some people do pay them on time. And the gap between the two rates was not related to the cost that it imposed on the finance company. I think that was wrongly decided. But anyway, in Paragon Finance and Nash 2002, the court found that the lender had discretion to vary the interest rates, but that is subject to the proviso that they're not to exercise it for any improper purpose. Anyway, they can't do so just whimsically. But keeping interest rates at 2 to 4% of those above those on the high street was not a breach of this implied term. It's not grossly exorbitant. The CCA rules out things which are grossly exorbitant. The lender was having financial troubles, and we had to take into account his business needs. So he'd acted properly. So in Davis Direct Loans 1986, the lender had not acted wrongly by having a 21.6 interest rate. The market rate was 17%. The court said there was a poor credit history of the borrower, and therefore that was quite a big risk to lend to him. So therefore it was right to guard against that by having a higher interest rate, and otherwise that people wouldn't get loans at all. So you can be above the market rate, but you can't be grossly above the market rate. And 4.6 percentage points, it was within the bounds of reason. So these extortionate credit provisions of the CCA were replaced by this new notion of unfair relationship in the CCA 2006. So the court can look into the terms of agreement. Not only that, but they can also look at the creditor's behaviour towards the borrower, says has it been unfair. The legislation doesn't say exactly what unfair is, and the court has to figure that out in itself, which is perhaps giving them too much latitude. But there's case law about this, about unconscionability, about there being mala fides, about an imbalance in bargaining power, which there always is. You're an individual. This is a multi-million-pound company. Come on. So to be strong isn't wrong. Anyway, the CCA 2006 says the court has a number of remedies to use if there's an unfair credit relationship. They can order any part of the agreement to be struck down, they can change the terms, or they can say the creditor has to take or refrain from taking a course of action. Okay, so then looking on to the next thing. So the case law on consumer credit legislation is about statute and not about equitable principles, really. So it appears the principles from this case are applicable to the court's equitable jurisdiction, which means it can nullify unconscionable terms. But we're not sure what how the new statutory regime is going to evolve. Onerous mortgage terms might also be challenged on the unfair terms and consumer contracts regulations. 1999, the FCA has to take into account the fairness of the terms of mortgages and other financial services contracts when they're issued by FCA authorised companies. A term is unfair if it's mala fides, if it causes a major imbalance in the parties' rights. There's always going to be some imbalance. If it's to the borrower's detriment, and the term will not be binding on the borrower then, but the rest of the agreement is left in situ. So Falco Finance and Goff, this was an important case. The court found the dual interest rate was against bona fide. So it was against the regulations. And they had borne in mind the borrower's poor bargaining position, and he was attracted by having no legal or surveyor's fees, and it seemed that the apparently low interest rate. The interest rate was calculated on a flat rate basis. So the interest was payable on the full loan amount for the whole mortgage term, irregardless of how much capital had been repaid. The judge said this was unduly harsh, and it was wicked. Therefore, the term was found to be unfair under the regulations. But this is different from the UTCCR. The Unfair Contract Terms Act 1977 is not applicable to mortgages of land. Toodle pip.